On Thursday, June 20th, the Karen Read trial continued with day 28, and we are almost to the end of the prosecution's case in chief. On day 28, the jury heard from 3 prosecution witnesses, and 2 of them were finally medical examiners. Those were Trooper Nicholas Guarino, Dr. Rene Stonebridge, and Dr. Irini Scordi-Bello. And if you've been watching with us so far, you know that Trooper Guarino began his testimony about some of the digital forensics on day 26. Drs. Stonebridge and Scordi-Bello, on the other hand, are the 2 medical examiners who conducted the autopsy of John O'Keefe's remains. We have been waiting for this testimony for weeks, and we finally got to hear what the autopsy results say about John's injuries and what might have caused them. Why the prosecution waited this long to get to them, I will never understand. The best guess that I can make is that maybe they wanted to end their case in chief on a relatively high note, except I don't exactly see that happening here based on what actually came out in their testimony. Granted, Dr. Scordi-Bello has not yet finished her direct examination at the end of day 28, but I can't help but feel that the medical testimony in this case is neutral and inconclusive at best. Watch until the end to see what I mean, and then at the end, I want to know what you think. Let's get into it. Okay, so before we get into the testimony of the day, you might be wondering whatever happened to Judge Cannone's ruling on the prosecution's motion to exclude the 3 defense expert witnesses. And at the very beginning of the day, she actually did come to a few conclusions. First, she said that it was in fact her determination that a Rule 14 discovery violation had occurred with respect to Dr. Russell's identification. I still disagree with that, but okay. Anyway, then she decided on a remedy for the violation. And like I said in the day 27 recap, the primary remedy was the open voir dire that the prosecution was allowed to have of Dr. Russell on day 27. And now Dr. Cannone said that this basically satisfied the unfairness created by the violation, and so she was fine with that being the remedy. That and giving the prosecution a week to identify and bring in a rebuttal witness to her testimony. So this is basically what I predicted what would happen. Now, on the question of whether these 3 can testify, and if so, how much, Judge Cannone ruled that all 3 of them can testify, but as to Dr. Russell and Dr. Rentschler, with some limitations. For example, Dr. Russell can testify about her opinion that the injuries to John's arm appear to be dog bite marks. However, the judge said that Dr. Russell cannot testify that she thinks those injuries did not come from an auto collision or some other source. And as for Dr. Rentschler, Judge Cannone was not as concrete in her determination, but she hinted that there may end up being a limitation on his testimony under the requirements of Massachusetts law. As the judge explained, in Massachusetts, an expert cannot testify about what caused an injury or a medical condition unless the expert is an MD. And Dr. Rentschler is the expert offered by the defense to testify about kinematics of the human body and anatomical features and more to help essentially explain the causation of John's injuries. Now, Judge Cannone didn't say that Dr. Rentschler couldn't testify, for example, about human anatomy and these other various features, but basically said he's going to need to stop short of giving an opinion that basically acts like a doctor. Given Dr. Rentschler's level of expertise and professionalism that we've seen so far, as well as the fact that he's testified a number of times before, one of those times apparently in a deposition in Massachusetts, I have a feeling that this is going to be something that he can totally navigate. Okay, so next the jury heard the rest of the testimony of Trooper Nicholas Guarino from the Massachusetts State Police. If you remember, at the end of day 26, Adam Lally introduced a series of text messages through Trooper Guarino. Those were messages between Karen and John that appeared to indicate, to my non-expert eyes anyway, that Karen and John were caught up in a bit of a contentious relationship cycle earlier in the day on January 28th, 2022. Karen seems to have wanted to relieve some anxiety with intimacy and attachment, and John's instinct was to seemingly be avoidant and create space for himself. The combination of the two, especially where the couple doesn't really see or understand the dynamic of what's happening in the relationship, can just reinforce itself over and over and over again. And so this is how a couple can find themselves trapped in a cycle like this. Anyway, next, Lally introduced 8 voicemails left by Karen on John's phone between 12:37 a.m. and 6:08 a.m. on January 29th, 2022. Keep in mind, throughout January 28th, when the two were fighting over text messages, Karen was also calling him. She apparently called him 18 times, and all but 3 of those times were either ignored or dismissed by John. And I'm not going to lie to you, the voicemails that they did play out in court on day 28 don't sound great. She's screaming over the phone at him, saying things like, "I effing hate you," and calling him a pervert. She's also accusing him of sleeping with another woman in that moment. Now, not all of these voicemails were really discernible, and the final one appears to be an actual butt dial where Karen is heard in the background screaming Jen and Carrie's names over and over again. In fact, we actually already heard this one through Jen's testimony. But just so you can get an idea of all of these voicemails, I'm going to play for you the ones that have some real substance to them. Here's the first one, which she apparently left at 12:37 a.m. immediately upon returning to John's house. Here's another voicemail, which she left at about 12:42 a.m. apparently.
"John, I'm here with your fucking kids. Nobody knows what the fuck you want, you fucking pervert."
Here's another one from about 1:11 a.m.
"Yes, 1 in the morning, I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert."
And here's one more voicemail from just a little bit later.
"John, I'm going home. I cannot babysit your niece. I need to go home. You are fucking using me right now. You're fucking another girl. He's sleeping next to me. You're a fucking loser. Fuck yourself."
So interpretations of what these voicemails mean can definitely vary. It seems that the prosecution is offering these to show that Karen had an insatiable rage towards John, I guess. Like she had just run him over and then wanted to keep raging at him with these voicemails. It also could be that they're saying that she was covering her tracks with these voicemails because she wanted to make it look like she was upset over thinking that he was cheating on her or something like that. But to be honest, to me personally, what the prosecution is actually trying to argue with this is fairly unclear. For my part, from what I had heard about these text messages in advance, I kind of was expecting there to be a bit more. Really, I thought that maybe there would be something along the lines of a confession or an admission from Karen that showed pretty definitively that she had hit John. But it seems to me that these voicemails just fit with what I already described about the attachment style cycle of their relationship. In the absence of any kind of a response from John, based on the fact that the allegation of his cheating came up multiple times throughout their relationship, it seems her mind went straight to that place where she thought that he was in bed with someone else. And this also fits with the testimony of Carrie Roberts and Jen McCabe, actually, who both said that while they were driving to look for John, they would mention one of John's ex-girlfriends who lived nearby. And each time, Karen would sort of perk up and say, "Do you think he could be there?" This seems to suggest a pretty important detail about Karen's mental state. Namely, it seems to suggest she thinks he's alive and cheating on her. Obviously, this does have to be squared with the fact that she also asked, did I hit him? Could I have hit him? And depending on how you view this bit of the evidence, maybe you also believe that she said affirmatively, I hit him. So all of that does need to be sort of squared because it's all coming from the mouth of the same person. But another thing to keep in mind is that she also says and even screams a lot of things throughout the morning that suggest that by the time she's talking with Carrie and Jen, Karen has wound herself up into a state where she's essentially lost her mind. And looking at the text from the day before, the 18 calls to John's phone, and then these new voicemails, this all looks like that wind-up in her mental state and emotional state seems a bit more logical, at least in the context of how her brain seems to operate. In other words, it looks like she didn't start winding up at like 3 or 4 in the morning on the 29th when he didn't come home. Rather, it seems that she started winding up at some point on January 28th when he ignored 15 of her 18 calls to him. So if anything, these voicemails actually make Karen seem less guilty to me. Unstable? Perhaps. Toxic in a relationship? Yeah, there's a pretty good chance of that. But those things don't automatically mean murderer, or else murder rates in the United States would be way higher than they actually are. Anyway, next Trooper Guarino told the jury about some more of the digital forensics that he analyzed from John's Apple Health data and the GPS on his phone. With the GPS, he basically showed a series of blue circles on a map that widened and narrowed every other second at 12:25 a.m. It seems they were suggesting that this was the time that Karen hit him with her SUV before driving off. And the widening and narrowing of the blue circles seems to be intended to suggest that the GPS was showing with pinpoint accuracy that John never went inside the house. The only problem with this is Trooper Guarino also said earlier in his testimony that in 2023, he went to do an analysis of the GPS signal at 34 Fairview Road, and that this showed that the place can be a bit of a dead zone. So personally, I was left with the impression that this bit of the testimony as to the GPS was a bit ambiguous at best. Now, as to the Apple Health data, Trooper Guarino also went over a timeline of steps that John's phone showed him to make that morning. Between 12:11 and 12:21 a.m., the phone said that John took 170 steps for 326 feet. Trooper Guarino said that at 12:12 a.m., John was at the waterfall and then got into the car at one point. And so this seemed to call into question the accuracy of those steps. But as David Yannetti pointed out on cross-examination, Trooper Guarino didn't know where in that 10-minute span John supposedly took those steps, or most of those steps, or some of those steps. Anyway, then between 12:21 and 12:24, John's phone says that he took another 80 steps and traveled up and down 3 floors of stairs. This is an important detail, since the defense is arguing that this is an indication that John was in fact inside 34 Fairview Road at this time. However, Trooper Guarino said that this can't be true because at 12:22 a.m., John's phone had the Waze navigation app open for directions to 34 Fairview Road, and this placed him on Oakdale, like a block away from the house at the time. And this is where we talk about Yannetti's cross-examination. I will say this didn't feel like Yannetti's strongest cross overall. He seemed to be getting caught in the weeds sometimes, and it felt like he would almost land some blows, but not quite. However, my overall personal impression is that most of this cross-examination was probably mostly to lay breadcrumbs for what the defense will get into with their digital forensic experts. These were things like Jen McCabe's alleged 2:27 a.m. Google search for Hoslong to die in the cold, and some potential phone calls that she allegedly made and then deleted. 2 of these were to apparently her sister Nicole Albert at 6:07 and 6:08 a.m., and one was allegedly to her brother-in-law Brian Albert at 6:23 a.m. But there was one point that Yannetti made that was really important here. Remember how I just said that Trooper Guarino said that the flight of stairs counter was basically impossible because Waze showed John all the way over on Oakdale at 12:22 a.m. at the same time that those stairs were measured? Well, Yannetti brought up a couple interesting points about this timing. One was a reference that Yannetti made to a 12:22 a.m. text exchange between Julie Nagel and her brother Brian Nagel when he showed up at 34 Fairview Road. There was an objection to this which was sustained because this witness wouldn't have necessarily known about this detail. Understandable. But this was an interesting detail for Yannetti to refer to nonetheless, because it seems that the defense is going to be casting doubt on the Waze timestamp because of the way that the stairs counter seems to line up actually with all of the testimony and text timestamps from all of these other witnesses showing that the SUV was already at 34 Fairview Road at 12:22 a.m. Now, the other thing that Yannetti brought up was the fact that there apparently are 3 different clocks that an iPhone might use. And each of these could in fact be off by as much as like 3 minutes. And when Yannetti asked Trooper Guarino which of these clocks the Waze app connected to on John's phone, Trooper Guarino basically said he had no idea. And so here we have yet another situation where an investigator may or may not have fully explored an important detail. Now, this is important because where Waze says that John was and when is being used here by the prosecution to argue that it was impossible for John to have been walking up and down 3 floors at a time because he was sitting in a car. And so I suspect that we will be hearing more from a defense expert on this to testify more definitively that Waze was in fact inaccurate in its timestamps. But we'll see. Anyway, before we move on to the testimony of the medical examiners, I wanted to talk about something actually enraging that happened in the middle of Trooper Guarino's testimony. Before his direct exam ended, the judge sent the jury out to hear a request by the prosecution to enter into evidence a Google search that Karen apparently made at 1:27 p.m. on January 29th, 2022. According to the extraction report from Karen's phone at that time, apparently she searched for a DUI attorney. And so the prosecution tried to argue that this was evidence of Karen's state of mind, specifically that she had a guilty conscience, because why else would she spontaneously think of hiring a DUI lawyer? Now, for one thing, the defense pointed out that the prosecution had conveniently left out the fact that at 1:19 p.m., just a few minutes before, Trooper Proctor had called Karen's phone, so the spontaneity of that thought is definitely called into question. But more importantly, the idea that any person's desire for a lawyer of any kind somehow indicates consciousness of guilt is insane to me, and it marks a new low by the prosecution in this case. This is a classic example of the state trying to take advantage of someone's rights at any possible opportunity. The mere fact that they're trying to make this argument is in fact proof that any individual coming in contact with law enforcement needs an attorney, because without one, their rights can be totally trampled by a prosecutor's rabid need for a conviction over justice. And the argument by the Commonwealth here just flies in the face of all of the logic that underpins a person's Miranda rights, for example. Under Miranda, where a person is under police custody while in an interrogation, they have to be offered, for example, the right to remain silent and the right to an attorney. And if they request an attorney, that request can't be used against the defendant in court to suggest that they're somehow guilty. It's the same with a criminal defendant opting to invoke their Fifth Amendment rights not to testify in their own criminal case. These are well-secured rights with tons of case law to support them, and the logic in this particular situation is very similar. So in short, to suggest that looking for a lawyer somehow means that Karen knows that she's guilty basically says that anyone who looks for or hires a lawyer in any area of law has done something wrong. The logic is so insane that I get into basically an apoplectic rage if I let myself think about it for too long. Now, thankfully, Judge Cannone ended up denying the prosecution's ridiculous motion. However, the fact that she didn't just summarily dismiss the motion before argument is also pretty astounding, I'm not gonna lie. Anyway, leaving all of that rage behind us, the next witness to testify was Dr. Nicole Stonebridge. She is one of the medical examiners who did an autopsy on John O'Keefe. Specifically, she examined his brain for evidence of potential trauma to it. And now, before I get into her testimony, I want to say something about courtroom fashion and courtroom appearances here because it was a topic that came up when she appeared. To me, for the most part, I think that her appearance wasn't an issue. She wore a beautiful green dress that on its own wasn't disrespectful of the setting, and her hair and makeup generally had a clean presentation. All of that is fine. The one issue that I saw for this particular venue, specifically being in a courtroom, is the fact that she had a full sleeve of arm tattoos. And now, let me get one thing straight. I don't have any problem with tattoos whatsoever. I think people can express themselves beautifully with their hair and makeup as well as with body art. And I find Dr. Stonebridge's tattoos to be incredibly beautiful, in fact. However, personal expressions through things like wardrobe and body art that might otherwise be totally celebrated and appropriately celebrated outside the courtroom may not necessarily be the greatest idea inside the courtroom. And this is because each of these witnesses that testify are coming in front of a jury that is made up of human beings. And whether we like it or not, two factors can be triggered by something like this. Number one, it can become a total distraction and people are not so much listening to the words that are coming out of the witness's mouth, but thinking about what is appearing in front of them. And second, again, whether we like it or not, people have all kinds of opinions about all kinds of things. And that definitely includes tattoos. And of course, we want to believe that the jury is making determinations about the testimony and about the evidence in this particular case and in any case for the right reasons. But the fact of the matter is there are people out there with impressions that tattoos indicate something negative about someone's intelligence or judgment or professionalism. And so my concern would be that there could always end up people on the jury who decide to discount what the expert is actually saying before she even opens her mouth. Long story short, my recommendation, as boring as it may be, is always to go more conservative for court and to reserve personal expression to basically the rest of the life that you live outside of court. Otherwise, you might just end up giving someone an unfair excuse to disregard what it is that you have to say. And in the case of Dr. Stonebridge, that would be especially unfortunate because actually, she is a highly qualified and intelligent professional, and overall, I really loved her testimony. In fact, out of all of the experts that the prosecution has called up to this point, I think that she's probably my favorite one yet. Not only does she clearly know what she's talking about like the back of her hand, but she communicates it in a way that is clear, engaging, and demonstrative. For example, as she was talking about different parts of the brain, she would point to those parts on her own head so that the jury could map out these different parts. She would use complex medical terms like subarachnoid hemorrhage and leptomeninges, but she would also slow down to explain what those are and how they fit in with her overall analysis. Unlike other medical experts that we heard from before in this case, it felt like we weren't getting medical terms just sort of thrown at us. We were getting a lesson in medicine. And this is exactly what you want from an expert witness. Okay, so what did she actually say in her testimony? Bottom line up front, she concluded that there was some kind of trauma that caused a series of injuries to John's brain. One of these was bleeding that apparently occurred in the membrane around the brain and around the spinal cord. Another was evidence that gray matter of the brain had been pushed against something, along with swelling in the brain that pushed downward. Now, when asked about the mechanism for the brain trauma, she testified that she thought it was caused by a blunt force. She didn't know how much blunt force, and she didn't know specifically what could have been the blunt object. She said it could have been the result of a fall, or it could have been the result of getting hit by an automobile. And so this is where her testimony was helpful to the prosecution, and the fact that they needed medical testimony that moved the ball forward somewhat, at least, to try to connect John's injuries with the idea that Karen hit him with her car. But beyond that, this testimony was actually more helpful to the defense than it was to the prosecution. At least, that's my opinion anyway. You see, no one in this case is arguing that John O'Keefe didn't die from blunt force trauma. That is generally undisputed. The difference here is in the mechanism. Was he hit by a car, or was it the result of, for example, a fist fight? And this expert couldn't say either way. And as I've been saying throughout this trial, it's the Commonwealth that has the burden of proof here. So if there is any ambiguity in these important pieces, the muddy middle goes to the defendant and suggests acquittal. Anyway, the last witness of the day was Dr. Irini Scordi-Bello. She was the main medical examiner who did the overall autopsy on John O'Keefe's body. She did the external examination and the internal examination to determine John O'Keefe's manner of death and his cause of death. And before we get into her testimony, remember that we've heard about this particular medical examiner before. It was in Trooper Michael Proctor's horrible text messages. If you recall, aside from the text messages that he had about Karen Reed that were terribly offensive and problematic in all kinds of ways, he also said at one point to a colleague something like, "Of course the ME decided that the manner of death was undetermined." And then he called her a whack job. So we knew in advance that Trooper Proctor had this sort of othering opinion of Dr. Scordi-Bello before we ever even met her. And once she did take the stand, the thing that instantly made me even more uncomfortable with Trooper Proctor's statements is this. She started talking and revealed that she has an accent that suggests that she was born outside the United States. Based on her name, I thought maybe she was Italian, but someone in the chat looked her up and said that apparently she's Greek. Really, it doesn't matter where she came from specifically. Right off the bat, it feels like there is a non-zero chance that the basis of Trooper Proctor calling her a whack job could be also rooted in xenophobia. So, add that to the list of Trooper Proctor's reprehensibility, it seems. Anyway, Dr. Scordi-Bello testified first about the difference between manner of death and cause of death. As she explained, cause of death is essentially the mechanism that caused someone to die, as determined by the details that are uncovered by the autopsy. Manner of death, on the other hand, is a determination based on the circumstances around the death as brought in via the investigation into the case. There are 5 possible conclusions for a manner of death. Those are natural, accident, homicide, suicide, and undetermined. Now, in a previous video, I said that there were 4 possible conclusions, which I want to correct here. I left out natural, which was a mistake. I think my brain left it out because generally that's not a determination that a medical examiner would make because their jurisdiction falls over cases other than natural causes of death typically. And that's because death by natural cause is usually where the death was under the supervision of a doctor because the person died from a disease like heart disease or cancer. Looking back at the list, accident is where there is a physical or chemical injury, but the circumstances don't show any intent by anyone to harm the person. As an example, Dr. Scordi-Bello mentioned motor vehicle collisions, interesting, and drug overdoses. Moving on down the list, she said the homicide is where the death was brought about by another person and where the circumstances suggest some level of intent. Now, of course, this is not a legal conclusion. This is a medical conclusion. There's different versions of intent, different definitions of intent. But moving on, suicide, on the other hand, is similar, wherein there is some suggestion of intent to cause harm, but where the death was brought about by the person who actually ended up dying. And finally, there is undetermined. According to Dr. Scordi-Bello, this is where the facts pointing to one manner of death are no more convincing than those pointing to any other. And ultimately, what Dr. Scordi-Bello decided in this particular case was that the death was in fact undetermined. Now, given the fact that the manner of death determination depends on the facts and circumstances around the death as uncovered by the investigation, I wonder why anyone looking at the results of this investigation would say that they couldn't definitively conclude how this all came about.
Red Solo Cup, I fill you up.
Anyway, When she talked about the cause of death, she basically concluded the same as Dr. Stonebridge in that John O'Keefe had blunt force trauma to the head. And ultimately, she said that this, along with hypothermia, was the cause of death. This was in part because his head injuries on their own probably weren't immediately lethal. Rather, it was the fact that he landed outside for some time afterwards, subject to the cold, that ultimately contributed to those injuries killing him. To get to this conclusion, she went over all of the external and internal injuries on his body. And according to the witness, all of the blunt force injuries were to his head. More specifically, she said that it was a blunt force to the back of the head that caused the bruising and swelling to the eyes, as well as a laceration right above the right eye. And similar to what Dr. Stonebridge testified, the idea here is that the initial force caused pushing and swelling inside the brain that essentially moved everything forward and down. And also similar to Dr. Stonebridge's testimony, Dr. Scordi-Bello also testified that she couldn't say how much force this was or what kind of object may have caused it. Then, looking at his arm, she noted that he had abrasions, which she said appeared to be scrapes of the skin. And still looking at his arms and then his hands, she noted the bruising on the back of his hands and said that that most likely was from an attempt to give him an IV drip. Now, looking internally, she said that John's blood alcohol content was also very high. And she said that this can be a contributing factor to hypothermia because alcohol can inhibit the body's ability to maintain heat. And all of the rest of the internal injuries appear to be caused either by hypothermia or, in the case of his broken ribs, the CPR attempts that were made on him. After this, Lally decided to go through a bunch of diagrams with the witness, as well as some photos of the scene to go over basically all of these details again. Why he didn't go through all of this concurrently with her initial testimony, I really have no idea. But anyway, that's where her testimony left off for day 29. Once we finish her direct and cross-examinations, it is expected that the prosecution will finally rest their case in chief.
It's been 84 years.
And at that point, I expect the defense to make a motion to dismiss the case. I don't expect them to win on that specific motion for reasons that I can get into later, but I see no reason why they wouldn't or shouldn't make this motion regardless. And after that, it will be all about the defense's case in chief, which is expected to be much faster than the prosecution's, like by a long shot. But all in all, I think that there's a little bit here that was beneficial to the prosecution's case through Trooper Guarino's testimony, perhaps. But how well that holds up might depend on how the defense's experts testify on similar subjects. And the medical examiners, well, the fact that neither of them can give clear conclusions as to the manner of death or the mechanism by which that head trauma happened, that's a big win for Karen Read because, as I said, muddy middle goes to the defense. But those are my thoughts. What do you think? Do you think the testimony of the day was more beneficial to the prosecution than I think? And if so, why? Do you think that Trooper Guarino's testimony about the GPS, Waze, and Apple Health data was compelling? What about those voicemails? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily coverage of the Karen Read trial, both in daily recaps and in gavel to gavel live streaming, be sure to hit the subscribe button and the notification bell so you can join us on our road to 250K subscribers, which we are almost there. And if you really want to support the content, consider becoming a member of Bike Club. You can join either through YouTube memberships or by supporting on Patreon, and doing so means that over the long term of this channel, we can continue to devote intensive resources to trials like this one and other interesting legal topics. Links to both are in the description below. Otherwise, see you on day 29.